the next lecture, and I'm really excited if you're still here, because we're almost at the end. This is lecture 9, and it's on legal contracting in venture capital. And it's not just for lawyers. I think a lot of people think, you know, these issues of terminology and cap tables, we're just going to leave to our lawyers. But as an entrepreneur and as a VC, you can't leave it to your lawyers. Your lawyers really don't have the context of what you are doing. So for your contracting arrangements or what you're trying to achieve. So for all your contracting arrangements, please, it's really, really important that you understand all the legal terminology and that you can have a discussion. It's actually more useful to the lawyers when you can have an intelligent discussion with them as opposed to them instructing you on what you should do. When you can speak to them and they give you some advice, you disagree slightly with the advice, you come up with a solution together, that's a lot better than just them giving instructions without the context of what your aims and goals are for that particular transaction. So let's move on to the legal issues in venture capital. Outline. In this outline, we'll be discussing term sheets, jurisdiction, intellectual property, and regulatory issues. And we'll start with the term sheet. So what is a term sheet? I defined it in the definition section, but I'll define it again. It's a written document that parties exchange containing important terms and conditions of the deal. And there are two things involved. Number one, the economics of the deal, the return that the VC or the angel will get if there's a liquidity event. And then number two, there's control as well addressed in that document, which is the veto decisions that the company can make, monitoring, reporting, board seats. So on a term sheet, it generally discusses two sets of things, economics and control. The economic part I'll be discussing first, which is what's the economic section of the term sheet discussing. It's going to discuss the price, it's going to discuss the liquidation preference, it's going to have a pay-to-play if there is one, vesting, the employee pool, and anti-dilution. So what's a liquidation preference? A liquidation preference gives the investor first right to any proceeds available to shareholders in the event of a liquidation or trade sale of the event. So basically, if you invest in a company and for some reason it fails, if you have a liquidation preference, would get first ability, if the company is sold or it has any assets that are sold, you would get first ability to get money out of that deal or out of that transaction. And some people have a 1x, meaning that we'd want to get exactly what we put in at the beginning of this transaction. Some people have a 2x. In later stages, you might even see a 3x. So it's a liquidation preference, but it gives downside protection, I guess, but it can also increase the upside to an investment as well. Pay-to-play. A pay-to-play provision in a term sheet requires investors to participate at the company's request in subsequent rounds on a pro rata basis. And if an investor doesn't participate when requested, they can face consequences like losing certain privileges. However, pay-to-play provisions are actually extremely rare. I don't think I've seen one in any deal recently, but they're just something that you can find on some term sheets, or in the universe of term sheets, it might be something that you might come across. Anti-dilution. I don't know why this is so controversial, but it is. So anti-dilution provisions are clauses that allow investors to maintain their right of ownership percentage, even in the event that new shares are issued. So dilution refers to shareholders' ownership decreasing as a result of new shares being issued. And there are two types of anti-dilution. There's a full ratchet, which could be unfair, I guess, but there's also the weighted average. My personal opinion, I don't have a problem with weighted average, and I'll tell you why. So a full ratchet is, okay, let's say that I invested in a company during, like right now, it's the beginning of 2020, and like startups are everywhere, we're raising money every few minutes basically, and the valuations are really high. So let's say that I gave a company $1 million at a $9 million valuation. And, the company didn't do too well. Started failing. They didn't hit certain milestones, and, everything was going to, it was going to be game over. And then an investor came in and said that he was willing to invest to prevent the company from going bankrupt. Wow. But what if he says he's only going to invest at a valuation of 4 million? Bearing in mind that we have invested at a valuation of 9 million like 4 years ago. So the full ratchet means that the valuation, the equity I own, will be adjusted to that 4 million. So it means I'm not going to be diluted in a down round. So what I wrote here is, therefore, they are protected if the new offering price is lower than the conversion on an investor's shares. So in case of a down round, there's downside protection, but a full ratchet, remember there's two, weighted average and full ratchet. So for the full ratchet, it's exactly, you come down. Yes, the new investor is coming in at 4 million. Me too. Me that I invested since. Why should my own not be 4 million if this new person is coming in at 4 million? So that's the full ratchet. But I do think that one thing it does do is, if you've got a really resilient entrepreneur, and they've been working, because sometimes companies fail for, like we said in the post-mortem lecture, companies fail for all kinds of reasons. And definitely, there's no correlation, and I've been doing this for a long time. I've not seen a correlation between hard work and success of a company. Some founders work very, very hard, but they just do not blow. Maybe the industry is wrong. Maybe times have changed. Maybe the technology changes. But it's not the most hard-working founders that do very well. We have to work hard to a certain level. But the people that have had companies fail, it's not because they are lazy people. And it's not because they didn't work just as hard as the people that succeeded. It's usually, for me, obviously you get the odd person that just didn't work hard and, ran away with the money. And you hear stories like that in Nigeria. But generally, it's not because the person is a bad person. So when there's a down round, should we penalize the founder that harshly? When they're even, some of them will tell you that they're not doing anymore, that they're not running the company. That in fact, they're moving to Germany, that they just won visa lottery, or they're going to America. So these are founders that actually stuck around and maybe with your help, maybe without your help, secured an investor. But it's a down round because you paid 9 million for it. The investor is only willing to come in and save the company at 4 million. So the question is, the full ratchet, a lot of people believe, penalizes the founders too much. Because if your equity reverts to what it would be at 4 million and you invested at 9 million, that means you're going to own most of the company, basically. And the founders are not going to own much anymore. So what's the point of them working if they own so little? So it can be discouraging to founders. And that's why a lot of agreements have the weighted average. So these are the disadvantages of the full ratchet. The company appears just less attractive, right? It may even deter some new investors from investing when they see that there's going to be hardly any equity left for the founders and their employees. And the new investor has said, look, I don't believe in that valuation, I'm investing in 4. Then if you have a full ratchet anti-dilution, it comes down to 4. But with a broad-based weighted average, you say, okay, I'm not going to punish you by coming down to the same amount as this new investor. So why don't we take the average of 9 and 4, and then I come down to that valuation. You lose something as a founder, I lose something as an investor. It's not as good as 4, but it's not like I'll still be holding that 9, because it doesn't make sense. So you come down to about 6. And that seems to be more acceptable because it's fairer. So, yeah, I've already compared the weighted average versus the full ratchet. It protects the investor more, but it's so harsh. So, that's the difference. Now we move on to control. And there's two mechanisms for control. There's board seats and there's protective provisions. So in terms of protective provisions, they're veto rights that investors have and sign on for certain actions by the company. So unless the VC agrees, the company can't change the terms of stock ownership, authorize the creation of more stock. The founder can't sell the company. So there's all kinds of things that you can put into your term sheet that protect you as an investor. And there's some things that you wouldn't think that you have to put in a term sheet, but we've seen all kinds of things. So put it, even if it's obvious. So sometimes you'll see, I've seen it in the Nigerian ecosystem, that a VC will invest in a founder, and the founder will leave the company and leave his employees in the office and go somewhere else, and will have been in that somewhere else for like 3 months and will stop picking his calls. You didn't put in the contract that the founder has to tell you before he leaves. You'd have assumed that that was normal. It is not. Put it in the contract. So protective provisions, anything that you want the company to adhere to, put it in your term sheet. So these are some of the protective provisions, and I'm sure you can think of a bit more, like borrowing money, for instance. Like, yeah, I think if you hold a significant stake in a company, then if a founder goes to borrow a large amount of money at a really, really high interest rate, it can affect your investment. So if you want to be alerted before a company does that, then again, you need to put it in one of your provisions on your term sheet. Otherwise, you have no right to start asking. It's not in your agreement. Or I wouldn't say you have no right, but the founder can turn around and tell you that we didn't have a legal agreement. I can take a loan whenever I like because it's not in the term sheet. So it's important to be able to spell out the protective provisions in the term sheet. And, some people will say that a founder and investor relationship, why does everything have to be spelled out? Like, surely you guys trust each other, and that's why you're investing in the company. I understand that perspective. But do you know that rich men, when they are getting married and they're in love, a lot of them still sign prenups with their wives. And a lot of rich women, they're in love, but they still sign prenup with their husband. So that, okay, if the thing goes wrong, at least I know how much money you're going to take. And if you can be doing that with the love of your life, then, you're investing in lots of startups. Are they all the love of your life? Just make sure that you spell the terms of your agreement in the term sheet. It may never come to that, and usually it doesn't. Honestly, in terms of founder relationships, most founders that you meet in the African ecosystem are some of the most hardworking, driven, innovative founders that you will ever find. And I've loved working with them. But that doesn't mean you shouldn't write things down. And if you want more information on this, Field, Brad, and Jason Mendelsohn, they have a great book called Venture Deals, where you can read about this a bit more. So this is another quote from Venture Deals, and it's about drag-along agreements. So this agreement gives investors, or the preferred investors, an ability to force or drag along all the other investors and founders to do a sale of the company, regardless of how the folks feel about being dragged along with the deal. So when they need to exit, basically everybody needs to exit. Understanding the cap table. So the cap table summarizes who owns what part of the company before and after financing. And a lot of founders don't pay enough attention to their cap table. They think the lawyers are looking, we've outsourced all that to the lawyers. Founders, it's very, very important for you to pay attention to your cap table, because some founders will just be giving out a safe note here, a convertible note here, another small safe note. Before you know it, when all of those things convert, when you do a big round, you'll realize that you own a much smaller stake in your own company than you even think that you do. So this is really important to do the math, or have somebody that understands the math of a cap table, and understand what you own. particularly when you're using a lot of safes and a lot of convertible notes or convertible debt that converts at a later time from when they were issued. Oh, and this leads us on nicely to convertible notes and convertible debts. So convertible debt is just that. It's a loan. And the loan will convert to equity at a time when another round is raised. And sometimes it has a discount on that future round. So features of convertibles. Most fans of convertible notes argue that it's much easier for the transaction to be completed than if you do straight equity. So number one advantage is no valuation is being set for the company. So you get to avoid that part of the negotiation. And then number two, because it's debt, not equity, there's certain controls that an equity investor would have on your company that they don't necessarily have. But one of the biggest arguments would be that, your legal fees will be cheaper if you do convertible note versus when you do equity. And that's not really true that much anymore because there are just so many standardized documents. But definitely the first two are true. So more features of convertible debt. Some argue that, it leads to higher pricing because it forces higher pricing, because some have a discount that says that, whatever subsequent investor comes in, we must have, as the holders of the convertible note, 20% between us and them. So yeah, they might argue that, and yeah, there might be some truth in that. Capped and uncapped notes. So convertible notes place a delay on the on valuation, of the company until a later funding round. So when entrepreneurs and investors agree to a capped round, that means that they place a ceiling on the valuation at which the notes must convert to equity. Whereas an uncapped round is actually more favorable to the entrepreneur. And it means that the investors get no guarantee as to how much equity their money purchases. Personally, I don't like uncapped notes because that means that I don't really know how much I'm able to, I don't know what I own. So I really don't like uncapped notes. But just to tell you, there are two types, capped notes and uncapped notes. And let me tell you something about uncapped notes. I'm going to go on a rant now. They actually present very perverse incentives. They pitch you against the founder. Let me tell you why. Because let's say I have invested in a company. The bigger that company grows, bearing in mind that I have an uncapped note, the less I am going to own. So why would I be bringing various businesses to the company when I know that the more the company progresses, the higher the valuation and the less I will own? It doesn't make sense. So I'm not a fan of uncapped notes, personally. I prefer capped notes. But each to their own. I'm sure people that do uncapped notes have their reasons behind why they do them. But I just think that, there's misaligned incentives there. Safe notes. I love this picture of a safe that I found, but safe notes are actually nothing to do with a safe, except I guess people think they're safe. But anyway, a safe note acts as a legally binding promise to allow an investor to purchase a specified number of shares for an agreed upon price at some point in the future. Many types of safe. Valuation cap, no discount. Discount, no valuation cap. Valuation cap and discount. Most favorable nation, no cap, no discount. And the only one, I've explained caps and discounts in the previous slide. The only one you don't know is most favorable nation. And the most favorable nation clause means that you give the person the safe. But then, if you have a most favorable nation clause, that means that the person, if anybody gets a better deal than you, of subsequent investors, then you automatically say that I want to invest along those same terms as the person that got the better deal, if there's such a thing as a better deal. So it's the most favored nation clause that you've added to it with no cap and no discount. So advantages and disadvantages of safe notes. I think the major pro that everybody talks about is a safe note is just simple and it's easy to account for in your books. However, it can be risky to investors because it's just a promise, it's just a paper. What if they don't give you the equity? That's never happened, but I'm just saying, well, it never happened to us. I've never heard of it happening, but it's a possibility. Number two, it doesn't provide any dividends. Number three, compared to a convertible note, it's not debt. So there's no debt or interest accruing on it. And dilution. Many investors don't think about the impact that the notes will have on the valuation of the business in future. So there might be dilution implications. And then lack of minimum requirements. So safes don't have a minimum requirement for equity to enter the conversion, which means it might have a negative impact on future investments. So minimum requirements actually allow you to adjust the notes terms, giving like smaller investors a chance to compete. So I think the main advantages of safes are, it's just simpler. No end date, no interest. And you can even draft one, you can download it. Actually, it was invented by Y Combinator and you can download it from their website and just adjust it to what you need and that's it. So it's virtually free, there are no legal fees. So why are we even talking about all these instruments in the first place? When I want to buy Zenith Bank shares, or I want to buy Presco shares, or I want to buy Unilever shares, or I want to buy Flour Mill shares, I buy the shares. What is the issue of safe notes and convertible notes and convertible debt and all of these things? Why do you need them? Why not just buy the equity like you do on the Nigerian Stock Exchange? Number one, it's quicker. These companies don't have value, or they don't have a clear valuation. And you can use these instruments, some of them without a clear valuation. Number two, it's cleaner. You can get it done faster. And in Nigeria, we have this term called wahala. So I'll say it means trouble. It's just less wahala overall. It's less cumbersome. It's just an easier way to invest. A lot of big rounds still do direct equity, and we've done direct equity before, but more and more, I'm seeing more safe notes and more convertible debt. Regulatory issues. So, when we're talking about legal issues when you're doing venture deals, I think it's really important to talk about regulation. Check if the country in Africa has capital controls, and that means do they control the amount of dollars that you can take out of the country? Because there's no good of an exit, right? If you're an American investor and you can't take the money out of Ethiopia. So just make sure that, if you've had a fantastic, everything has gone well, you've had an acquisition, and then you can't take dollars out of the country, then what's the point? Right, so that's one of the issues, and then changes in policy as well can take your company out of business, and then how good is the stakeholder management? And that's why I think it's really a good idea when you're investing in Africa to come in with a local fund, because you have people then that can do stakeholder management and public relations on your behalf. Intellectual property. Does your company have a local patent, an African patent? Does your company have an international patent? What are the IP laws? Can people steal from your company? Where's the company registered? Where's the jurisdiction? What kind of protection is the company offered? And then, in terms of intellectual property, it's really, really important. Common law countries that operate common law tend to be more successful and attract more investment compared to civil law, because obviously judges can interpret common law and use their discretion to interpret situations that perhaps they haven't come across before. Whereas civil law, if there's not a law backing that transaction, then that's more or less it. And that really discourages innovation and discourages venture capital. So those are things to look out for. Jurisdiction. What's the tax regimen at play in your country? So this year, before, there was actually very little capital gains tax in Nigeria. Now it's about 10%. That's just come in. It was signed in 2022. So that affects when you have an exit. What are the tax implications for you? So that's something to check out, and it's different for different African countries. Capital controls are spoken about. Macroeconomics, inflation, devaluation really affect your investment. IP laws are spoken about, and regulation. So Uber, all I'm going to say, everybody is really familiar with this case study. It's from Bloomberg Law if you want to read through it fully. But it's just about understanding how changes in policy can affect, or changes in the law can affect your business. So right now, in most countries of the world, I believe, all Uber drivers are classified as contractors. That means that Uber is not responsible for their healthcare, is not responsible for their pension, is not responsible for their sick leave. If an Uber driver gets sick today, he's on his own. Uber is not paying sick leave. It's not a salary. If you get ill, then abandon your car and get well. That's what Uber is telling you. They're not going to tell you that, during this period that you're sick, I'm going to continue paying you until you get well. That's not their business. If you like, take 1 year to recover and then come back to drive Uber, but you're not an employee, you're a contractor. But there are some states in America that are trying to stop that, and they're saying that it's exploitative. The company as big as Uber needs to take these people as employees. That creates a new level of expense for them. So legal issues, policy issues are things to watch out for and understand in wherever you're investing. And different countries in Africa have different approaches to policy issues. Last lecture, portfolio construction and monitoring in venture capital and angel investing. If you've made it to the end, I am so personally proud of you.